Yeah, very quickly, the Supreme Court ruled that in many cases commission payments could be legal, but also that in circumstances yet to be prescribed and which wasn't part of their deliberation may not be fair. So, for example, in the case of Johnson, the size of the commission paid and the manner in which it was disclosed in terms of transparency led to the conclusion that the relationship was unfair. The Supreme Court stated, as many of us will know, that several factors could indicate an unfair relationship and contravene the CCA, whilst equally recognising it depends on the facets of each case individually, which is very helpful when someone like Mike is trying to set up a process for a past business review. And just for those who aren't aware, the factors could include the size of the commission. I believe Johnson was 55% relative to the charge of credit. The nature of commission, whether it's discretionary or non, the characteristics of the consumer, again, does that imply that some customers would be excludable because they're sophisticated? All these things we're yet to learn. Compliance with regulatory rules. Interesting in this case that you could argue it was compliant in terms of disclosure, but the transparency, placement, etc., of the actual disclosure was what caused the scrutiny, hence the extent and manner of the disclosure. The FCA will now have to consider the above when deciding which cases should fall within the scope of a redress scheme. Unlikely that's going to be straightforward, in our opinion, not least things like opt-in, opt-out. When I read this, and we spoke to a number of our legal contacts, it felt as though whether or not that be Treasury pressure or influence, the FCA was looking to reduce the cost and reduce the burden on lenders by way of an approach to this. However, when Mike and I spoke about this recently, we're just wondering if it's in some ways the opposite, because you're having to upskill the type of people doing that work. So there are those type of considerations, not least when does commission stop being fair and becomes unfair? Is there a pivot point, etc., etc.? So FCA now committed to do a consultation for October 25. Beyond this, the FCA anticipates that scheme will be finalised in time for complainants to start receiving compensation scheme next year. And whether it be opt-in, opt-out, combination of the two, depending on circumstances, I think will be really interesting for those of you who've got backlogs of complaints, and whether or not you can carve any of those out, or whether or not they have to stay in pending some other type of approach the FCA have yet to prescribe. Do you want to carry on this point, Gary, or are you going to?
Yeah, I think so. Yeah, please.
Yeah. So if we look at the implications for stakeholders, what might that be? So for creditors, there's going to be a much larger potential for exceptions in the population, a lot more work to determine where a complaint has a case. For consumers, a lot more confusion about whether they qualify for a payment. Do they have to opt in if they've made a complaint already, etc.? Are they going to have to try their luck via CMCs if some PBRs are unclear, too aggressive, lack of consistency in approach across the industry? For CMCs, is this a lifeline back into motor finance again? I personally got the impression the FCA were trying to discourage customers from using CMCs where possible to ensure a smoother process for all. New complaints will be filled potentially with time-consuming DSAR requests by CMCs who want to dispute your outcomes. And for brokers, car dealerships, there's now perhaps got to be a refreshed review of fair value assessment from a consumer duty lens. And looking again at the B2B2C relationship, CMC focus will be split between creditors and those at the end of the commission payment. So overall, I can't help thinking there are going to be a big need for complaint handlers for anyone with a backlog of complaints. Over to you, Gary.
Thanks, Gary. So on that basis then, where we expect a kind of lower redress provision overall because of the exclusion of kind of non-DCA as a kind of an en masse blanket kind of opt-in, but the greater complexity in having to assess the complaints I want to run a second poll now, if that's okay, based on the cost and time required to conduct the remediation process. What impact did this ruling have on the likely cost of remediation if you exclude the actual redress payments to the clients? And we'll give you kind of 10, 20 seconds to have a think about that one, as I've given you lots of options with lots of numbers in there. Fab, I think that would be great, Diane. If we can see the results. Wow. I guess the kind of just over a third of you struggling to quantify might be the reason why there's such a split across all of these.